The corridors of power and the grand halls of justice have always been wrapped in an aura of absolute impartiality, presenting an image of a system where the truth remains sacred, and no individual or institution is beyond accountability. For centuries, the public has been led to believe that the legal framework of a nation stands as an unbreakable shield against deception, designed to protect the vulnerable and expose the wrongdoings of the powerful. Yet, behind the heavy mahogany doors and the solemn dignity of the courtroom, a completely different reality often unfolds, leaving ordinary citizens and global icons alike to question whether the scales of justice are truly balanced, or if they are subtly weighted in favor of those who command immense influence. When a prominent public figure chooses to step out of the shadows of tradition and challenge one of the most formidable entities in modern society, the stakes are raised to an unprecedented level. This is not merely a legal dispute over administrative errors or minor contractual disagreements. It is a profound and deeply personal battle against the systemic overreach of a media apparatus that has long operated with a sense of near-total impunity. For decades, the boundaries between public interest and private life have been aggressively blurred, creating a culture where the intimate details of an individual's existence are treated as a commodity to be bought, sold, and weaponized for financial gain. As we peel back the layers of this escalating conflict, we begin to see the outline of a narrative that challenges our very understanding of fairness, transparency, and the rule of law in the modern era. To understand how we arrived at this critical juncture and to ensure you do not miss any updates on this rapidly unfolding story that is shaping the future of public accountability, please take a brief moment to subscribe to our channel, turn on all notifications, and join our growing community of analytical viewers who demand depth and truth in global news. The atmosphere surrounding this modern legal saga is heavy with historical resonance, echoing past conflicts where the boundaries of privacy were shattered under the guise of journalistic enterprise. For generations, the relationship between influential figures and the mainstream press has been defined by a tense, symbiotic dance, where mutual dependence frequently gives way to bitter hostility. However, the dawn of the digital age and the fierce competition of the 20th and 21st centuries transformed this dynamic into something far more predatory, where the relentless pursuit of exclusive stories began to justify increasingly invasive methods. Wealthy media conglomerates built vast empires on the foundations of sensationalism, recognizing that the public's appetite for the hidden lives of prominent individuals was virtually insatiable. In this high-stakes environment, the traditional ethics of journalism were routinely tested, and as allegations of unlawful information gathering began to surface over the years, a dark underbelly of the industry was slowly exposed to the light. The public watched in fascination and horror as revelations of intercepted communications, compromised personal spaces, and specialized surveillance tactics shifted from the realm of conspiracy theories into documented legal facts. Parallel cases involving other major media networks had previously demonstrated that the rot ran deep, with courts consistently finding that private investigators had been deployed on a massive scale to extract secrets from unsuspecting targets. These prior legal victories created a sense of momentum, establishing a precedent that gave hope to those who had suffered in silence, suggesting that even the most powerful media giants could eventually be brought to heel if enough evidence was brought before an impartial judge. Yet, the latest chapter in this ongoing struggle has sent shockwaves through the legal community and the public at large, shattering expectations and reigniting a fierce debate over the integrity of the judicial process itself. The expectations were incredibly high as a coalition of determined claimants, united by a shared sense of violation and a desire for institutional reform, presented what they believed to be an unassailable mountain of evidence, detailing years of coordinated intrusion. They brought forward documentation, witness testimonies, and chronological alignments that pointed toward a systematic pattern of behavior designed to breach their most private moments for the sake of daily headlines. The anticipation surrounding the verdict was palpable, with observers across the globe expecting the court to maintain its historical trajectory of holding invasive press practices to account, especially given the striking similarities to previous landmark rulings. Instead, the final determination delivered from the bench felt to many like an abrupt and inexplicable reversal of a long-established legal direction, a decision that seemed to actively disregard the patterns of the past in favor of a narrow, rigid interpretation of responsibility. The reaction from the claimants was immediate and unfiltered, characterized by a profound sense of disillusionment and anger that transcended the standard disappointment of a lost lawsuit. They openly questioned how a system could look at parallel sets of facts, involving the same time periods and identical investigative methods, and arrive at a conclusion that effectively absolved a massive publishing house of any liability, raising the uncomfortable question of whether different rules apply to different players in the grand game of societal power. The core of this escalating controversy lies in the dramatic and public condemnation issued by Prince Harry, the Duke of Sussex, and his fellow claimant, Baroness Doreen Lawrence, following a British High Court ruling that completely dismissed their years-long lawsuit against Associated Newspapers Limited, the powerful publisher of the Daily Mail and the Mail on Sunday. In a blistering, unfiltered statement delivered to the media immediately after the verdict, the 41-year-old royal and the 73-year-old activist openly called out the court's decision as a whitewashed outcome that defies common sense and undermines the foundational principles of justice. They declared with absolute certainty that they had come to the court seeking nothing more than basic accountability and a fair evaluation of the facts, but instead received absolutely neither, leaving them deeply shocked by the lengths to which the judicial system has gone to completely exonerate one of the largest media conglomerates in the world. The claimants did not mince words, explicitly pointing out that this judgment represents a total and baffling reversal of the positions which previous high-ranking judges had taken in relation to highly similar phone hacking and information-gathering claims successfully brought against other major press groups, such as News Group newspapers and Mirror Group newspapers. Strikingly, Harry and Lawrence highlighted a profound irony in the system, noting that the very judge who delivered this unfavorable ruling had actually represented those rival media groups during the time when those parallel hacking claims were actively unfolding in the courts. This specific detail has added a thick layer of tension and public skepticism to the entire proceeding, as observers question the institutional consistency of a judiciary that seems to apply entirely different standards depending on the corporate identity of the defendant, according to the statement released by the Duke and Baroness. The High Court wholly ignored generic findings about various private investigators that were already held by the courts in parallel claims to have carried out extensive, coordinated, and deeply unlawful activity at the exact same time in relation to similar sensational stories and well-known individuals. They argued that the court displayed an inconsistency which is exceptionally hard to understand or reconcile with any standard of objective common sense, choosing to completely dismiss a massive body of evidence that had been meticulously compiled and presented over the entire course of the trial. For Harry, the best-selling author of the deeply revealing memoir Spare, and Baroness Lawrence, a widely respected civil rights campaigner, the ruling feels like a calculated attempt to protect the press at the direct expense of individual citizens. They alleged that the High Court clearly operates under one rule for the newspapers and an entirely different, far more punishing rule for the claimants. They pointed out that while their legal team presented extensive, compelling documentation of illicit surveillance, the journalists and executives representing the Mail simply offered blanket denials, which the court chose to uncritically and completely believe. This uncritical acceptance occurred even in the face of glaring inconsistencies, massive contradictions, and blatant untruths that were obvious to any neutral observer sitting in the courtroom and comparing the verbal testimonies against the cold, hard data contained in the written documents. Despite the crushing nature of the ruling, both Harry and Lawrence concluded their public address by expressing their deepest gratitude to their legal team for their exhaustive hard work, and praised the brave witnesses who possessed the immense courage to come forward in the pursuit of accountability. To fully grasp the magnitude of the legal hurdle the claimants faced, one must look at the specific rationale provided by the High Court Judge Matthew Nicklin, who ultimately ruled entirely against the favour of Prince Harry and his co-claimants. In his formal summary, Judge Nicklin acknowledged that the allegations brought against Associated Newspapers Limited were undeniably serious, involving claims that the media giant routinely utilized highly invasive listening devices placed secretly inside personal cars and private homes, alongside hiring a network of private detectives to illicitly harvest private data from the early 1990s all the way through to 2011. However, the judge concluded that the claimants had ultimately failed to prove that the specific information used to publish their articles was obtained through these unlawful means. In a crucial legal distinction that has infuriated privacy advocates, Judge Nicklin wrote that the court rejected the fundamental argument that simply because information was inherently private, and because Associated Newspapers could not positively or clearly explain how it had been originally sourced, the relevant article must have been unlawfully obtained. This reasoning effectively shifts the entire massive burden of proof onto the victims of media intrusion, requiring them to uncover the internal, hidden corporate tracks of journalists who operated in total secrecy decades ago. Associated Newspapers Limited has consistently and aggressively denied every single allegation of wrongdoing, maintaining that all of their printed information was obtained through entirely legitimate, conventional journalistic sources, a defense that the High Court has now completely validated, leaving the claimants with a crushing defeat that completely halts a legal battle they began back in 2022. The emotional and personal stakes of this trial were vividly illustrated during Prince Harry's intense personal testimony, where he laid bare the profound psychological toll that the British media's constant invasion of privacy has inflicted upon his immediate family. The Duke shared with the court the painful reality that his wife, Meghan Markle, was forced to live in absolute and unrelenting misery during her time residing in the United Kingdom as a working member of the royal family, a direct result of the relentless, predatory behaviour of tabloid journalists who refused to grant her a shred of human dignity. This deep-seated trauma continues to dictate the family's logistical and personal decisions to this very day, casting a long shadow over Harry's current trip back to British soil. The former military helicopter pilot arrived in the United Kingdom early this week, specifically to promote next year's highly anticipated Invictus Games, which are scheduled to be hosted in the city of Birmingham. Originally, the plans dictated that Harry would be joined on this trip by the 44-year-old former Suits actress and their two young children, 7-year-old Prince Archie and 5-year-old Princess Lilibet. However, in a stark reminder of the ongoing security and privacy anxieties that plague the couple, Meghan and the children ultimately chose to remain behind at their home in the United States. This decision was made directly after the British government denied them taxpayer-funded, official security, a refusal that Harry has previously argued makes visiting his homeland far too dangerous for his wife and children. Caught between a hostile press and a legal system that has rejected his pleas for justice, the Duke was forced to face the public alone, stepping onto a stage at Chatham House to deliver a welcome address at an Invictus Games conference, just moments after receiving the devastating news of the judge's ruling. The dramatic intersection of Prince Harry's crushing legal defeat and his public appearance at Chatham House underscores a deeper structural conflict that defines his modern life away from the traditional confines of the British royal family. Stepping onto the stage to address the 14th Invictus Games Foundation conversation, titled From Policy to Practice, the Duke of Sussex demonstrated a remarkable ability to compartmentalize immense personal disappointment in service of his global charitable mission. Founded by Harry in 2014, the Invictus Games have grown into a globally celebrated international adaptive sporting event for wounded, injured, and sick servicemen and women, serving as a powerful testament to the resilience of the human spirit. The upcoming Games, scheduled to take place in Birmingham, represent a highly symbolic return of the event to British soil, a project that Harry remains deeply passionate about despite his fraught relationship with his homeland. Yet, the stark reality of his family's absence from this promotional tour highlights the unresolved fractures within his inner circle and the state infrastructure. The refusal of taxpayer-funded security forces the Duke to navigate his public life in the United Kingdom under a constant state of heightened alert, creating a physical and emotional distance between his past life as a senior working royal and his current reality as an independent global advocate based in California. This security dispute is intricately linked to his wider campaign against the tabloid press, as Harry has long argued that the hostile media environment directly fuels the physical threats and intense harassment that necessitate high-level protection for his wife and young children. To fully understand the gravity of this legal showdown, it is essential to examine the unique background of his co-claimant, Baroness Doreen Lawrence, whose presence in this lawsuit elevated the case from a standard celebrity privacy dispute into a profound examination of institutional ethics. Baroness Lawrence is one of the most respected and influential civil rights campaigners in modern British history, having spent over 3 decades fighting for justice following the tragic and racially motivated murder of her 18-year-old son, Stephen Lawrence, in London back in 1993. Her tireless advocacy exposed deep systemic flaws and institutional racism within the Metropolitan Police Force, leading to landmark judicial inquiries that fundamentally transformed British society. For a figure of her immense moral authority to join forces with Prince Harry against Associated Newspapers Limited demonstrated that the grievances against the publisher went far beyond simple irritation over gossip columns. It was a battle against what they perceived as a systemic, predatory culture of surveillance that targeted vulnerable individuals during moments of profound personal crisis. The allegations that journalists utilized illicit methods to gather information during the height of her family's grief struck at the very heart of journalistic integrity. By dismissing their collective evidence, the High Court's ruling has left these two vastly different public figures united in a shared sense of systemic betrayal, reinforcing their belief that the legal framework is designed to shelter massive media operations from true accountability. The history of Prince Harry's specific legal battles reveals an unprecedented strategy for a member of the House of Windsor. as he became the first senior British royal in over a century to actively take the witness stand and give detailed, under-oath testimony in a court of law. For generations, the royal family has adhered to a strict institutional mantra of never complain, never explain, choosing to endure press intrusion in silence rather than risk the unpredictable exposure of a public trial. Harry's decision to break this multi-generational protocol signifies a deep personal conviction that the media's overreach must be challenged, regardless of the reputational or emotional cost. His legal campaigns have spanned multiple fronts, targeting not only Associated Newspapers Limited, but also other major publishing giants, where he previously achieved notable successes that established historical precedents. These prior victories, which included substantial financial damages and formal admissions of wrongdoing from rival publishers, had fueled widespread public expectation that this current case would follow a similar trajectory. The sudden halt brought by Judge Matthew Nicklin's ruling, therefore, marks a massive institutional pivot, drawing a sharp line in the sand regarding how far the courts are willing to go in forcing media companies to disclose their internal historical sourcing methods. The legal precedent set by this dismissal could have far-reaching consequences for the entire British media landscape, potentially signaling to investigative journalists and corporate executives that blanket denials are sufficient to withstand even the most serious allegations of historical privacy violations. The broader implications of this verdict stretch across the global media industry, raising critical questions about the future of privacy protection, corporate accountability, and the boundaries of investigative journalism in the digital age. Privacy advocates argue that by placing an almost impossible burden of proof on the claimants, the court has effectively created a protective shield around wealthy media organizations, making it exceedingly difficult for private citizens to challenge illicit data collection. When a system rules that the sheer privacy of an information piece and a publisher's inability to explain its origin do not imply unlawful sourcing, it creates a high legal barrier that few individuals possess the financial resources or endurance to overcome. For Prince Harry and Baroness Lawrence, the battle represents a deeply personal crusade for truth that has cost millions of dollars and years of intense public scrutiny. As the Duke of Sussex returns to his family in the United States, the echoes of this legal defeat will undoubtedly influence his future strategy, potentially